Okay, hi guys. We're letting everybody go ahead and come in to the webinar today. Thank y'all so much for being here. My name is Jamie. I'm going to be the moderator for today, and we are going to be doing a Championing for Change, special education training for parents and caregivers today. If you haven't already noticed, your video and audio are automatically turned off for the duration of this webinar. We will have a recording available within the next 2 weeks after the end of this. Let's see, and if you do have any questions throughout any of this, during any of the slides, please go ahead and drop them in the Q&A option below. We will have a designated time at the end of the session for Q&As, but if some questions come up during, we can answer those too. And we also ask that you help us keep this session as accessible as possible by limiting chat posts. Please use the private message feature to say hello to friends or to have any side conversations. This will help ensure our attendees using screen readers that they can hear the speakers properly. And then also in the chat, there will be a link for our closed captioning that is happening live for the duration of this event. And if you have any questions or need any help with anything, please message me privately and it will read DRA moderator. So we have our two guests today with us, our staff attorneys, Kyla Bishop and Jennifer Goodwin, and they will be taking over. So, all right, guys, thank you.
Okay, well, again, welcome everybody. Thank you so much for joining us today. We're really excited to be able to put on this training, for parents and, advocates and caregivers alike on, how to navigate the special education IEP process. So we hope that you guys will get a lot out of this today. If you have any questions, let us know. And we'll have our Q&A session at the end. Okay. Okay. So a little bit about our agency. We are the independent, private, nonprofit protection and advocacy organization for the state of Arkansas. So we assist people with disabilities in exercising their civil rights. We our services include information and referrals, short-term assistance, technical assistance, legal representation, advocacy, monitoring, and training, such as like what we're doing today. We are independent from state and local government. I always want to be sure to include that in there. We are independent from them. So we just want to quickly advertise our new resource, IEP and the Power of Three, You, Your Child, and Your Knowledge. Like I said, this is one of our newer resources, has a ton of information in it, everything that we're going over today. And we also have resources in there, including a printable IEP binder template and blank sample IEP forms. So the link at the bottom of the screen is where you can go and download it, and I highly encourage everyone to do so as we're going through the presentation.
All right, you guys, let's go ahead and get started. I am Jen Goodwin. I think they introduced me earlier, one of the attorneys on our education team, along with Kyla. So just wanted to say thank you guys all for coming and being a part of this today. So I also wanted to add that if you have questions along the way, feel free to go ahead and ask them. We will try to answer questions on the fly as we can and then catch anything that's missed at the end as well. So let's just jump right in on what is special education. And so it is specially designed educational instruction, and it's to meet the needs of a child with a disability. So, and then looking at that is what is an IEP, otherwise known as an individualized education, and you'll hear the P as either program or plan. Those tend to be interchangeable. I think the official word is program, but anyway, it is the written document of how the school will administer the specially designed instruction. So a lot of times you'll hear about IEP meetings. And so that will be a whole team of people that'll come together to the table to go through what needs to be in that individualized plan. One of the key words there is individualized. And so it shouldn't be based on, oh, just the disability in general. It shouldn't be based on the whole class. It shouldn't be based on anything like that, anything other than the specific person that is being designed for. So it shouldn't be a big copy paste job. It should be a bunch of people sitting at a table and deciding what is best and what's going to help that particular student that you're discussing at the time. Okay, next, Kyla. Okay, so the IEP process, and this can get a little confusing sometimes on what are the steps. You know, I get this from parents all the time on where do I even start? Or a lot of times people have never even heard of what an IEP is. They know that their kid is, you know, maybe it's got some disabilities, maybe it's a new diagnosis, maybe it's something that they've had that they've known about for a long time. But a lot of times parents are kind of lost on, okay, I know that my kid is starting to fall behind in school and it just seems like they can't keep up, or they're having behavioral concerns that, you know, they're getting suspended, or even talking about expulsion or ALE process or any of that. So what can I do to help my child out? So I wanted to kind of simplify that and looking at what the IEP process is. So there is a federal law about child find. So that is that the school has to identify children who have disabilities and who need special education services. But on the flip side of that, parents can also bring those concerns to the school. And the school has to listen and take notice of, okay, well, you know, maybe we need to evaluate this a little further. So, and other people can do that as well. So it can be the parents, it can be advocates, teachers, administration, any of that can, you know, look at a child and say, okay, maybe we need to really look into this a little bit further and see if there's some special help that we can provide for this student to be successful in school. So that's the first step in this process, is the child find process. And then at that point, they can be referred for an evaluation. So during the referral process, they're going to look and say, okay, well, we need to bring everybody to the table and just decide. It's a referral meeting. And so everybody will come to the table and decide, is this person appropriate to be evaluated further to see if they have some individualized needs that can be addressed through an IEP. So at that point, if they decide, yes, we need to move forward with that, then they'll have to have consent from the parent, and then they'll look into doing an evaluation. And so with an evaluation, it's very comprehensive. There are lots of tests that they'll go in and do to help determine if this student is eligible for an IEP at that point. And then they will determine the eligibility. They'll come back to the table and they'll have some recommendations from the people who have administered the test. And so they'll have that recommendation, but ultimately it's a team decision. Okay, based on these test results and what we're seeing, and based on the recommendation from the test taker, and then everybody at the team. So that's the parents, and we'll go into that a little further about who needs to be at that table on a later slide. But that team together will determine if the student is eligible. And if they are, then they're going to go in and draft the Individualized Education Program or plan. And so that's just a whole written document. And one of the key words that I want to make sure that we're emphasizing here is written, because basically if it's not in the written document, then it doesn't exist. So there are court cases on that, on whether it was, you know, just a conversation that was had in that room versus whether it's actually in writing. So as a parent, you're going to want to follow up and make sure that what was said in the meeting actually got put onto the paper, because you're going to want to make sure that all of those protections are in there for your student. And then once we have an IEP established, then we're going to go through, and it will last for the year unless there need to be some changes made. And so we always say that an IEP is a very fluid document and that it can change at any time. So a parent can request a meeting at any time to come back to the table, or, you know, administration or teachers, whoever. If it's not working, then it needs to be adjusted. And, you know, that happens often. A lot of times, you know, you go in with an initial plan and you think it's a great starting point, at least, and maybe it is, maybe it's not. But then you'll have to, you know, reevaluate throughout the year. But at The least amount of time is that every year there needs to be an IEP review. So they're going to go in and everybody's going to sit down at the table at least once a year just to make sure that you're meeting goals. And if you're not meeting goals, that those need to be adjusted or the process changed so that you can make sure that you're going to get to meeting those goals. Each year, you're going to be looking at that. And then every 3 years, it's called a reevaluation. And so they'll actually go in and redo some testing if needed and look to see, make sure that you still are eligible for special education services and that there's still that need there, and then how to address those needs going forward. All right, and so this is something that comes up all the time on the timeline. So now I have parents ask me regularly, okay, well, when should I hear back from somebody and what kind of timelines are we looking at? And I'm not going to say it's a quick process because it's not, because a lot of these things do take time to get them established. And whenever you're working with a whole team of people, you're working with schedules and that sort of thing. But there is a timeline for a reason, and it is to make it as expeditious as possible. So on the timeline for an IEP, so whenever a parent comes, or whoever, parent, teacher, whoever comes and requests a referral, to school has 7 days from the request of that referral to schedule a meeting with the parent. So within 7 days of saying, hey, something's off with my kid and I feel like we might need to have them evaluated. So the school will have 7 days to contact you to set a meeting time. And that's not to say that meeting needs to happen within 7 days. It's just that there needs to be one scheduled within that time frame. And then they have 21 days from then to hold the meeting. So 21 days later, so 3 weeks after you initially request, then there needs to be a meeting done to establish, the referral piece of this. After that, if the team decides that they should go ahead with the evaluations, then they've got 60 days from that date to complete the evaluation. Because a lot of those are very comprehensive and they require, specialists, all that sort of stuff, to go in and evaluate the student. So they've got 60 days to do that. Then after that evaluation is done, the school has 30 more days to schedule a meeting to go over the evaluation results. And then within 30 days, the IEP services must be provided no longer than 30 calendar days following the IEP meeting. So, it's like I said, it's not a super quick process. And what's unfortunate about that is that can be, nearly a whole semester. So I would just encourage you that if you do see some need for your student, then go ahead and request as soon as possible and keep up with these timelines. So that way, you can make sure that the school is being accountable to get things done as quickly as possible.
Okay, so now we're going to kind of get into the details. Jen kind of gave you a quick overview of everything, but, what does that mean, when you get down to it? So referrals. So a parent can make a referral for special education services, but that is not limited to the parent. Any school staff that may suspect that a child has a disability can also make a referral for special education services. I always recommend parents make a referral to, either teacher, principal, school counselor, special education director. Best practice is to send it to multiple people. That way more than one staff puts eyes on it. Always make your request in writing, either letter or email, so that you have proof you made that request, and keep a copy for your records. This is important so that you can keep track of the timelines. So just to quickly review, the school district has 7 days from the date of the referral request to schedule the meeting. And then that meeting must be held within 21 days of the initial request. And that timeline, it starts once the parents or the referrer's request is submitted. So always make sure to keep copies, make sure you keep a note for dates for timeline purposes. So evaluations, the student must be evaluated for all suspected areas of disability. So like Jen said, this is comprehensive. We want a comprehensive, holistic view of the child so that we can adequately program for them. So these evaluations include such as health, vision, hearing, social and emotional status, intelligence, academic performance, communication status, and motor abilities. It's important to remember that, an evaluation is not a single test, but it is a set of activities, a set of assessments. So, we need to have not just one measurement, in order to determine whether the child has a need for special education. Also, if the parent has any relevant medical evaluations or documentation, be sure to share that with the school. Always, you can provide it, via email or, provide them with a physical copy. I tell parents if you provide schools with a physical copy of the evaluation, just make a note of when and who you dropped it off with. And they have 60 days to complete these evaluations. As we said, it's a while, but at the same time, we want to allow enough time for the evaluations to be conducted and evaluated for all the suspected areas of disability. So determining eligibility. It's important to note that the evaluations or a disability in and of itself does not establish eligibility for special education services. The question is, do these evaluations establish that the student has a disability? And what are the student's educational needs resulting from his or her disabilities? So if the evaluation, yields that the child needs specially designed instruction, then the child requires special education. And so what does specially designed instruction mean? It means adapting content, adapting methodology, changing the way you deliver the delivery of instruction to the child. Any related therapies they may need to access their education. If the evaluations and the child's disability require that need, then the child is eligible. So let's say the school conducts an evaluation and the parent disagrees with the evaluation results for whatever reason. Parents have the right to request an independent educational evaluation. This is at no cost to the parent. However, I always caveat this with if the district feels that their evaluation is sufficient, they do have a right to defend it in a due process. So that's just an important caveat for that one. So now that we've established eligibility, everyone, agrees that the child needs special education services. Now we have to actually create the IEP. So, what is an IEP? What goes into an IEP? Why do we have a written document? That's what we're going to be getting into next.
Okay, so there are several different things that are required to be in the IEP. So the present levels of academic achievement and functional performance. So it's kind of where the student is now. Measurable annual goals. And so a lot of times you'll see these where it'll say student will complete a math function test, and it'll have specifics in there. 8 out of 10 times on by a certain amount of time, that kind of thing. So it's looking at something that can actually be measured. So that's the measurable annual goals. Statement of special education, related services, supplementary aids and modifications. So those are all the different things that need to happen for the student. So everything that needs to happen, such as like speech therapy, occupational therapy, physical therapy, counseling, any of those sorts of things that need to be added in there, the related services. And so those can be or need to be in the IEP. The explanation of the extent, if any, to which a child will not participate with non-disabled children in a general education. So with that, you'll see different things on it. I think it says like 80% of the time or above on with their non-disabled peers. And so it's just looking to see if they're going to be with non-disabled peers throughout the entire day or what percentage of the day. And those are usually check boxes that they can do there. And then accommodations on state and district assessments. So if they're going to need to be accommodated on those different exams. And then the frequency, location, and duration of services. Excuse me. Okay. Just a second. Okay, so IEPs have to consider the child's strengths, the needs of the child, the concerns of the parent, and the evaluation information. So positive behavioral interventions and supports, strategies to address the behaviors. So a lot of times we'll have students that have behaviors that are associated with their disabilities. And so they'll need to go in and talk about how those behaviors are going to be addressed so that the student can be successful in the classroom. A lot of times students have communication needs. So they need to address how those are going to be resolved. And then language needs and Braille instruction for a child who is blind or visually impaired. The IEP needs to be in place at the start of each school year. And then if a student transfers to a new district, then there needs to be a comparable IEP immediately, or they can just adopt the old IEP until they can develop a new IEP with the team. So they're required members on the IEP team. I think we discussed this a little bit earlier, but this is who's actually going to be at the table with you. So one of the key people there is the parent. So the parents need to be involved every step of the way. So I always say whenever I'm talking to new parents that become clients is, you're going to be at the table for the next however many years that your student's going to be in school. So make sure that you're showing up and make sure that you can keep an open line of communication with the school and the people involved. So that way you can be an integral piece of this. At that point, you also need your regular education teachers, a special education teacher, a representative of the public agency. So this is someone who's qualified to provide or supervise the provision of specially designed instruction to meet the unique needs of the child. They have to be knowledgeable about the general education curriculum and knowledgeable about the availability of resources from the public agency. So this is usually like your local education advocate as well. So they need to be in there and know exactly what's going on as a representative of the district as a whole. And then an individual to interpret evaluation results. So if you've had all these evaluations done, you need somebody who's knowledgeable to actually be able to interpret those results so that you're not just going off of what people think they mean. They actually need to have somebody qualified in there to talk about that. And then this is a big one for me, the child, if appropriate, for them to be in there. Once a child is a teenager, for sure, I feel like in most instances, they should also be at the table because we're discussing them and how best to make them successful in a school. So if at all possible, then the student should be involved as well. And sometimes it's not completely practical and not necessary for the student, but in a lot of instances, really consider if it's going to benefit that student to be at the table. And conversations do likely need to change if the student is at the table, because it needs to be very positive and uplifting to make sure that that student is not going to leave a meeting harmed. Like, you want to make sure that their thoughts and their feelings are taken into account if they're going to be there at the table with a whole group of people talking about them. It doesn't need to be something that's going to harm them at that table. It needs to be something that's going to be positive moving forward, and they can feel like they've been empowered to make a plan that's going to work for their success. Okay, so transition services. And this is a big one. So if you've got a student who is getting into their teenage years, so this is the question of, well, what do you want to be when you grow up? I feel like kids are asked that all the time, usually starting, from a young age, and kids with disabilities are no different. They need to start thinking about, what are my plans for after school, and what do I want to be when I grow up? I mean, that's just a standard question that we ask a lot of people, and these students need to be included in that as well. So beginning not later than the first IEP in effect when a child turns 16. So that's kind of your base standard, but it can be before that, especially students with more severe disabilities that are going to take some more time to get to those goals that are needed. So this includes appropriate measurable post-secondary goals based upon the age, appropriate transition assessments related to training, education, employment, and independent living skills if appropriate, and transition services, including courses of study needed to assist a child to reach goals. So what we're talking about here is you've got a student who's at the table and they literally say, okay, well, what are your plans for after high school? And if that student says, I want to go to college and I want to get a career in XYZ, then we, look at them on that career path and decide, okay, well, what do we need to do to help them to be successful in getting admitted into a college, or scholarships that may be available, that sort of thing. And then, where they want to live, and do we need to work on some independent living skills to be able to get them onto a college campus? And do we need to work on driving skills? What do we need to do that's going to make them be the most independent that they can be? And how do we get them there? We'll also be looking at PREETS. So PREETS is Employment Transition Services. And so there are 5 different pieces to that. It's career explorations, work readiness skills, counseling and guidance for post-secondary education, work-based learning. So that is working for pay or volunteer work within the school or in the community. And then instructions and self-advocacy. So this is the point that the student needs to start really learning how to advocate for themselves as well. So, up until this point, maybe mom and dad have been the ones who've really been advocating to make sure that their needs are met. Well, the student needs to start, catching that baton and moving on so that they can advocate for themselves and learn how to do that going forward into life after high school. Okay, so there's some more to that. So coordinated set of events or activities for students. It needs to be based on the individual needs with the student's strengths, preferences, and interests included. And then instruction in related services, community experiences, development of post-school goals, acquisition of daily living skills, and provision of functional vocational evaluation. So all of those different things. I mean, that's looking at what courses the student is going to take to be ready for the next steps after high school. A lot of times the school will offer maybe jobs within the school, or they will provide links to jobs outside of the school that the student can actually go to and work and get paid at, so that they can start learning those job skills, as well as getting into learning money management, all of those sorts of things that are really important for everyone and these students included. And so we just want to make sure that they are receiving those services. And for that, that student needs to be at the table because they need to be the one who's determining which path their life is going in. And the school is just made to help navigate that with them and help get them to their goals. Okay, so extended school year. And a lot of times this is school that's going through the summer. So a lot of times parents think, oh, well, this is just summer school. And it can be used, for my student who got behind and they're, maybe they're not passing this semester, that sort of thing. But that's not really what extended school year is about. So extended school year is special education and related services provided to the student with a disability beyond the normal school year. And it goes according to the IEP and it's no cost to the parents. But as I said, it's not summer school. So this is more for students who, if they go that full, 3 months during the summer, then it's going to cause them to have regression. They're not going to be able to, it's going to take them longer to get caught back up when the school year starts. It's pretty natural for everybody to lose a little bit over the summer just because they're not practicing those skills during that time frame. But for some students, it's going to cause a really deep regression where it's going to take months for them to get caught back up just to where they were in May before the school year let out. And so with the extended school year, it allows that continuation of services. So they're still going to get whatever related services that are necessary during that time frame. And then they're also going to still receive instruction during the summer for that. But I do want to emphasize that it is not just your standard summer school. And it's not just to get kids caught up on what they've missed during the school year. It's just to keep them where they need to be successful going into the next school year.
Okay, so educational placement in least restrictive environment under the IDEA. What does this mean? So educational placement refers to the setting in which the IEP will be implemented, right? Now, the IDEA or IEP law requires that all school districts, educate children with disabilities in their least restrictive environment. Now, what does that mean? The least restrictive environment mandate requires school districts to educate children with disabilities alongside their non-disabled peers to the maximum extent appropriate. So we only move children with disabilities away from the general education classroom if their disabilities require it. And so you can see here on this spectrum, we have the general education classroom as the least restrictive placement setting. The child is receiving all of his instruction alongside his non-disabled peers 100% of the time. And then as we move away from the general education classroom, that is when we get more restrictive, with the most restrictive being education at home or homebound, or education being provided in a hospital. And so the least restrictive environment, this is important, especially when considering, before we had the IDEA, children with disabilities were often, sequestered in subpar educational facilities where they experienced, abuse and neglect. And this is just to prevent that and make sure that, children with disabilities aren't being inappropriately removed from their non-disabled peers. So there are several things that the IEP team has to take into consideration when determining the least restrictive environment. But most importantly, the decision has to be made by the IEP team. And the IEP team has to make their decision. They have to base their decision on the child, the evaluation data, and the placement options. So again, this is an individualized determination. We can't say, okay, all, kids with ADHD and autism, have to go to the ALE. That's not what we're doing. Each placement decision is individualized. These placement decisions have to occur annually. They must be based on the child's IEP, and they have to be as close to the child's home as possible unless otherwise agreed on. So we want to make sure we're not sending a child with a disability, halfway across town if we don't need to. So what are the considerations that the IEP team must make when determining the child's least restrictive environment? So the child must attend the school they would attend if he or she were non-disabled unless otherwise agreed upon. The team must consider any potential harmful effects on the child or the quality of services he or she needs. And the child cannot be removed from an age-appropriate regular classroom setting solely due to needed modifications in the general education curriculum. They should have those modifications provided in the classroom. And so I want to, we want to talk quickly about, disciplinary removals. First and foremost, school district can remove a child with a disability if that child violates a code of student conduct. However, the ability of the school to suspend and expel that child is limited. So first, what type of removals are we talking about? We're talking about both formal and what we call informal removals. So out of school suspensions, in-school suspensions, those are the more typical formal type of removals. And then you have the informal send homes. So, let's say the school district calls you, at 10 a.m., hey, you need to come get, Timmy, he's throwing chairs, we can't deal with it. Or, they call at 2 o'clock, an hour before school lets out. And says, come pick them up. Those informal send homes do qualify as removals. And then also removals to alternative learning environments. Typically, each school district has these, and those do count as removals. It's important to note that in whatever removal, the student is still entitled to a free, appropriate public education. So they still have to implement the IEP, and the child still has to access their IEP services. So manifestation determination reviews. As we said earlier, the ability of a school to suspend and expel a child with an IEP is limited. Often we have students whose disabilities may, manifest in maladaptive behaviors. And so if the student is removed in an excess or, for 10 days, the student is removed for their placement for 10 days, the school district must conduct a manifestation determination review. And so what is a manifestation determination review, right? So that is when the IEP team gets together and they determine whether the act of misconduct that triggered that 10th day and any past removals were a manifestation of the child's disabilities. So more formally, was the conduct caused by or had a direct and substantial relationship to the child's disability, or was the conduct the direct result of the school's failure to implement the IEP? Because remember, IEPs have to contain positive behavioral interventions and supports to address any behaviors that may be interfering with the child's ability to access their education. And that can come, that can look like just single, accommodations or modifications. That can include a behavior intervention plan or both. And so this will determine the student's placement. So if the team determines that the conduct was a manifestation of the student's disability, they have to return the child to the placement in which he was removed. So, let's say we have, a child who, was in the general education classroom with pullouts. They had a manifestation determination review and determined it was a manifestation. The school could not then, suspend the child for, 5 more days. They would have to return back to the general education classroom along with some extra steps. So what are these extra steps? So if the team determines that the behavior was a manifestation, they have to conduct a functional behavior assessment if one hasn't been completed already, and implement a behavior intervention plan. Now, functional behavior assessment is an assessment performed to determine the function of the child's behavior. So why is the child acting this way? Is he being triggered? What supports does he or she need? Et cetera, et cetera. And all that data, that data from the assessment is then taken and used to create a behavior intervention plan. And a behavior intervention plan is, it's a formalized plan to address behaviors that, may be interfering with the child's ability to learn. And these are supposed to be positive. That's really important. And they need to be based on the child. So, we can't have a copy and paste behavior intervention plan. This functional behavior assessment should be an opportunity to really analyze these behaviors to determine, what's causing them. And so if the team or if the child already has a behavior intervention plan, the team must review and amend that plan to address the behavior. And as I said, return the child to replacement unless otherwise agreed on by the parent in the school district. So if a parent disagrees with a team's decision, so the team determines that it was non-manifestation, the parent can appeal that decision by requesting a due process hearing. So I always want to be sure to include this interim alternative educational settings. So a child can be automatically removed for 45 days without regard to whether it was a manifestation of their disability if the child does any of the following. They carry or possess a weapon, they knowingly possess or sell illegal drugs, controlled substances, or they have inflicted serious bodily injury on another person. So the first two are kind of self-explanatory, but what does serious bodily injury mean? That's a pretty high bar. A slap on the wrist isn't going to cut it. Not even a bite covers it. Serious bodily injury means serious bodily injury. So again, that's a high bar. And so this interim setting is determined by the IEP team. Typically, this looks like homebound. I see most schools just do homebound instruction for 45 days, but it's not always that. If the parent disagrees with that placement decision, they can appeal by requesting a hearing. So just important to remember, they can be removed for 45 days, without consideration to their disability if they carry or possess a weapon, use or possess drugs or controlled substances, or inflicts serious bodily injury. And then alternative learning environments, we want to include these because we've been seeing an uptick in referrals to these environments. So they're often presented to parents as structured environments that can better meet a child's needs than placements within, the regular school setting. However, we often find that students are sent to these ALEs without ever being identified for special education services. And so, they're being removed away from that, general education setting. So again, we just want parents and, advocates to know, be on the lookout for this. There are various state requirements for ALE placements. There has to be plans for how the student will, exit the program, among other things. So, if you already have a child that is in an ALE, refer to the ALE handbook for, exit plans is what I call them. And, you can ask the IEP team to reconsider an ALE placement at any time. Remember, it's an individualized determination that must be based on the child. So, and then, all right, and I will hand it back to Jen.
Okay, so procedural safeguards under IDEA. So basically, this is, you have to give prior written notice. So the school is to provide written notice when the school proposes or refuses an action. So they have to let you know what's going on at all times. So that way they can't be holding meetings without you, any of that sort of thing. You need to be given notice before they change your student's placement, and the team needs to come to the table and discuss it. Consent, school has to obtain parental consent before they conduct an evaluation, before there's an excusal of an IEP team member. So sometimes you'll hear that if you have a team, even everybody's at the table and somebody needs to go tend to their classroom, something like that, they'll ask you, hey, do we have your permission for this person to be excused from the meeting? And so you can say yes or no. And if the answer is no, then the meeting may need to be rescheduled or something like that. So, or that person will just have to stay and be there. This can also happen, if somebody shows up sick the morning of the meeting, something like that. And, you can decide as the parent if it's somebody who's integral to the discussion. If they need to be there, then the meeting needs to be rescheduled to where all of those team members can be there. Otherwise, they just have to give you notice and you can consent to that. Accessing the parent's public or private insurance to pay for educational services. We hear this a lot. So a lot of times, if you're on a PASS or some Medicaid services, then the school will actually use that health insurance to cover some of the services that are provided at the school. But the school has to have consent from the parent for that. Fully informed of all relevant information and fully describes that activity. So parents just need to know what's going on, essentially. The parent needs to be able to have participation in the meetings. Access to educational records. We have had this come up several times where a parent will call and say, I requested those students' records and they wouldn't give it to me, or they told me that it was school policy that they can't give out the students' records. Well, you as the parent are entitled to have those records. And so make sure that they are giving those records. I know as an attorney or as an advocate, if I were to call the school, I just want to give the flip side on this. If I were to call the school and request your records, they would need to have a release from you as the parent or the guardian to allow me to access those records. So that is something under federal law that the records shouldn't be going out just to anybody. It has to be someone that you approve for those records to go to. But you yourself should be included in that list and be able to get your students' records. I want to go ahead and say on this as well, as an education attorney, we do recommend that from the very beginning, from your first IEP meeting and maybe even before that, keep a binder of everything that you need. So keep just a running copy of the current IEP, any functional behavioral assessments, any extra things that you think that your student might need. Just keep it all in a binder because you're going to need it, know it going forward and into forever. And so that can be something physical in front of you or something electronic. If you're communicating electronically with the school on a regular basis, then keep a folder on your computer that's got all of that information in it. But it is really handy to have those all put together. Don't just come home and throw the notes on the table and let it get lost with the junk mail. Make sure that you're keeping up with all of that stuff so that you'll have it as you need it, because that is a running record of what's happening with your child. And you want to make sure that you are aware of everything and don't have to try to find it, especially when you call us and you're like, oh, I don't know where all that information is. It's really nice whenever we can see that straight away. And also keep a timeline. Like if you're having repeated instances at the school where maybe your kid is getting suspended or in trouble for all sorts of different things, I just recommend keeping a timeline as you go of what's going on, so you can see, you know, just written in front of you of what's happening with those students. So, and then an independent education evaluation, that's another part of the procedural safeguards. I know Kyla already mentioned that earlier, so I'll just let that stand as it is. But if you have questions about that, you can ask us as well. Okay. Okay, so going into dispute resolution, and then this is going to be our options for this. So looking at the administrative exhaustion requirement. So this is basically, we can't just go jump straight to state or federal court. So I'll have people come in and say, I just want to sue the district, you know, whatever. And, you know, so there are some options that we've got to do before we get to, let's just go file for damages in state or federal court. And there are some options, some that you have to do, some that you don't have to do, but there are options out there. So mediation, that is what you would think about with standard mediation along the way. It's offered free through Bowen School of Law. So you can actually call the law school and request an education mediation. So what that's going to do is it's going to be a neutral fact finder that's going to come sit at the table with you guys. And the school is going to be involved and the parents are going to be involved. And you can have a parent advocate at the mediations. Right now in the state of Arkansas, they don't allow attorneys to be at that table. I understand there may be some change in that pretty soon, but right now attorneys are not allowed in mediations. But you can have somebody from the law school who is there. And so that way the parents are given their point of view and the school's given their point of view. And then they're trying to meet somewhere in the middle. So this is more like what you would think about with like a settlement, something like that, where just the meeting of the minds, making sure that it's opening up a facilitation of communication to be able to come to terms for the student. And that a facilitated IEP meeting is very similar to what I just described, but it's actually having attorneys are allowed to be the facilitated IEPs. And so with that, you still have your neutral fact finder. They're just kind of leading the discussion, is what it has seemed like for me, is that they're just there and making sure that everybody can kind of stay on track with the conversation. This happens a lot if there's been a breakdown of communication where it just gets really hostile between the parents and the school. And, you know, usually it's when things maybe aren't going right. And so you need somebody else to be in there just to kind of set the tone of the conversation and make sure that that line of communication is open. So other than that, you can do a state complaint or a due process. State complaint is whenever you are alleging a violation of a requirement in the IDEA. So a complaint in, you know, a federal law. So it has a 1-year statute of limitations. You can look back a full year to see if there's anything that's gone wrong in the school. And so this is kind of where I was talking about that timeline, and that I would encourage you that if you see a pattern of things that are happening that you feel like just aren't quite right, start making a timeline, because you can look back a whole year and have all of those listed in there. And in that form, there's a form on the Arkansas Department of Education website that you can go in. It's kind of a standard form that you can fill out. With that, the people from Arkansas Department of Ed will assign a team. They'll go in and do an investigation. So they're going to be calling the parent or whoever filed the complaint and getting interviews from both sides. So they're going to interview people at the school, they're going to interview the parent, the student if it's appropriate, those sorts of things, and then go in and make their findings. And so then they list what their findings are. And so that way the school is held accountable to be able to go in, and whether it's extra training or providing extra services for the student, whatever it is that's said. And so they'll either substantiate or unsubstantiate each claim that's in there. And you can have multiple claims in a state complaint, or it can be, you know, just something specific that you need to have listed in there. But key for that is that going back 1 year and the state is going in and doing the investigation. And then the next option is a due process. So with that, it can be filed by the parent or a public agency. So it's alleged a violation relating to identification. So that's like your child find issue, evaluation, whether they were evaluated appropriately and what that evaluation said, or educational placement of a child with a disability, or the provision of FAPE for the child. So if you feel like your student is not receiving the free, appropriate public education, or they're just not getting the appropriate placement, any of those sorts of things can lead to a due process. With this one, we said state complaint went back 1 year. Due process can actually go back a full 2 years. So you can look further back to see, what else has been going on and help establish that pattern of what's happening. It gives you an opportunity to resolve the complaint prior to an impartial due process hearing. So that is one of the mandates in there, is that there can be a resolution meeting. And so with that, it's just both sides of the table coming together to discuss what a resolution would be. And honestly, most due process complaints are resolved in this manner, and that, both sides can come together and say, okay, well, I maybe can't go the whole distance of what you're asking for, but we can meet in the middle here. Or yes, we can do this, this, and this for this student, and not have to go forward to a full hearing. And then, but if you do need to go to a hearing, that's okay too. That just looks a little more like a court setting. And it's just going all the way through. And then it's, you're calling witnesses, you're bringing in people from both sides. Anybody who has good knowledge of the student and the student's needs can be a part of that hearing. And so you're going to be questioning people and doing cross-exam and all the sorts of things that you think about in court. So not a reason to get nervous, but it does up the ante a little bit in what you're expecting. So a lot of people aren't super comfortable with that, but sometimes that's what it takes, and we can go that route if necessary. But a lot of those do get resolved early. One thing that I want to add in here is the stay put provision. So unless it's agreed on otherwise during this whole process of due process, then the student's going to stay in their current placement. So that can be a big benefit for a student. So a lot of times we'll have a student who is being recommended for expulsion or an extended suspension, something like that, or a placement to a therapeutic day treatment, or to an ALE, change of placement, something like that, that they're looking to move the student to, and maybe you as the parent don't feel comfortable with that, and you don't feel like it's appropriate. And so that is one of the things with the due process. It invokes the stay put. So the student will stay at their current placement until the matter is resolved, unless agreed upon otherwise by parent and school district.
Okay, so communicating with the IEP team. First and foremost, the parent is a full and equal member of the IEP team. So they should be in regular contact with them. Email is an easy and convenient way to keep a record of, who you spoke with, what you talked about, when this conversation occurred. And that can be important. If you provide the school with any physical documentation, as I said earlier, just be sure to note when you dropped it off and who you dropped it off with. So I always recommend, if possible, sending things electronically. The same goes for phone calls. Keep note of who you spoke with and what was said. A lot of the time, we can pull up our phone and, we can see when a call happened and who it came from, but, we may not have any information, or we may not remember, what that conversation was about. And so if you're getting a lot of phone calls, you're just going to want to keep a note of that. It's important to be a strong advocate for your child, but it's also important to be a respectful and professional team member. So, always show the IEP team, respect, when you're working with them. if you experience hostility from the school, don't get down in the mud, just stay firm and, keep advocating for your child. Keep things professional, because at the end of the day, this is about the child and what the child needs. And we want to stay focused on that. If it's needed, propose a communication log between you and the school district. This can look like, just a daily behavior report or a weekly behavior report. And a lot of school districts do this anyway, but if yours doesn't, and, there have been, maybe issues at the school or with communicating, you can propose that log and add it as part of the child's IEP. So just remember to, stay professional, stay firm in your advocacy. You're in this for the long haul. So, you're going to be working with the school district for a long time. And your child works with these people as well. So, we want to keep things respectful and professional. So that was the end of our presentation. We wanted to open up this time for any questions from the audience, anything that may have came up during the presentation. Any questions you guys may have?
Kyla, we have quite a few too that we can read through in the question and answer part. If you want me to go through some of those, we can answer those together if you like.
Yeah, if you don't mind.
Okay. So I'm going to kind of go in reverse. Well, actually, we'll just go back to the top and start there. So, Jacqueline, your question is probably going to be something that we should address personally, because there's a lot of detail in that. If you want to give us a call, we'd be happy to talk to you further about that one, if that's okay with you, because there is a lot going on with that question. Shannon, so even in meeting the eligibility requirements for the IEP, should the student have to receive a written test score of 90% or above in order to receive special education services through their respective school district?
Written test of 90 or above. I'm not sure what test that refers to.
I wasn't sure.
But we would go back to, when we're determining eligibility, we don't base it on just one assessment. It's supposed to be based on various assessments. So again, I'm not sure the test that's being referred to, but whether that test says that or not, that single test shouldn't be the determining factor.
Okay, another question here is, can a teacher who notices something about a student request an assessment for IEP?
Yes, ma'am. Yes, they can. That can be, that's typically submitted to their special education director. I've seen that happen, but yes, a teacher, a school counselor, any school staff can also make a referral.
Okay. And here's another one. My son has been under an IEP since kindergarten. This is the first time I hear about extended school year, which I think is beneficial, specifically to keep them with the progress they've reached. No one in the public school special education department has talked to me about this. To whom should I initiate the discussion to get him access this summer?
So what I would do is email or communicate with the IEP team, request a meeting, request what, in your request, be sure to mention that you want to discuss extended school year services. If just depending on how that meeting goes, you may consider a call to the Arkansas Department of Education or making a complaint.
Yeah. And I'll go ahead and say on that one too, there should be a box that's checked yes or no on extended school year in your IEP. So you may look back at that and just see, sometimes there is a conversation about why they took that yes or no. So you may look at that too, because it should have been a discussion that was mandatory at the meeting too. Okay, so next question. What do you do if a teacher is not using data to create goals for the IEP?
So, school districts are required to base their IEP special education services on scientifically backed peer reviewed data. So what does that mean? You know, they can't just be shooting from the hip. They can't just be taking guesses. So when, you know, if I were involved in that situation, then I would ask, okay, then what is the teacher using to make these goals? Because on the goal sheet, it will have a little box and it says this goal will be measured by tests, observations, you know, grades, et cetera, et cetera. So I would ask the teacher, you know, how are we making these goals? And, you know, that's where I would start that conversation.
Okay. So next is, can we challenge the disciplinary removals if we feel like it's not true?
Oh, I don't know. That's tricky. Typically when we file due process complaints over removals, it doesn't involve or we don't necessarily take into consideration or whether it's, you know, true or not. I don't think I've ever had one of those. Jen, have you?
And my question would be to that person. So if you feel like it's not true and that the incident didn't happen, or that you feel like the disciplinary removal was inappropriate based on what did happen. So um, if you feel like the removal is inappropriate for what happened, then yeah, I would say you could question that. And then if they're still removing the student, I mean, I think that's going to come back down to a manifestation determination review that Kyla talked about earlier. If the student is being removed for longer than 10 days throughout the school year, and it is a manifestation of their disability, they need to have that MDR, so that manifestation determination review, to determine if it's a manifestation of the disability. If it's not, then they could go forward with removal. If it is a manifestation, then they can't remove them for longer than the 10 days, except for the 3 big offenses that Kyla discussed earlier as well. Um, so I guess that's a true lawyer answer of it depends on the situation. And from that question, I can't tell you exactly what the answer to that is. So, all right. Next one. Can a child be in a self-contained classroom without a behavioral plan? The child was placed on half days without one.
I would say the child needs to have a behavioral plan. If they're being removed, you know, I would ask, are they having, you know, the same behaviors in the classroom? And, you know, did they perform a functional behavior assessment or try a behavior intervention plan before the self-contained classroom? But if we're experiencing behaviors and the child is on a half day because they, you know, for whatever reason, you know, can't go a full day, then the district needs to implement positive behavioral supports and interventions so that they can go for longer or as long as they can. So I would say, yes, that child would need a behavioral intervention plan.
As far as the first part of that question on can they be in a self-contained classroom without a behavioral plan, that answer is probably yes, but again, it depends on
Yes,
the
yes.
situation and why they're there. So, but if they're looking to the MDR at that point, then at that point they need to be doing a functional behavioral assessment to determine what the function, so what's causing these behaviors, and then a behavioral plan to help correct those behaviors and get them to where they can stay in the school.
And it's important to note that shortened school days are not positive behavioral interventions and supports. So, while parents can agree if they want to for a shortened school day or shortened school week, but the district must be taking other measures along with it. So talking about, the functional behavior assessment, the behavior intervention plan, gathering data to see, what do we need to implement for this child to access their education and stay a whole day.
Okay. Next question is looking back at extended school year. Is the school required to provide a paraprofessional in the extended school year if a student has a paraprofessional in the regular school year? I'm going to say it depends on this one too. Sorry, I know you guys hate this answer, but it truly is dependent on the situation. So a lot of times if you're in an extended school year situation, it may be an extremely small class. Sometimes it's even a one-on-one type setting, something like that. So the team will need to discuss what's appropriate in that particular setting for the student. So I think that it depends is probably going to have to be the answer there. Kyla, have you had this question come up specifically?
I have not, no, but as you were saying, it's going to be really dependent on each situation, and you guys are welcome to reach out to us, via email or through our online help form, so that we can kind of get into more of the details, because it is really dependent on each child.
It is. So probably the blanket statement on that would be whatever the child needs during that time. And so that's determined by the IEP team. But that need may change based on the situation for the summer setting versus your regular school year setting.
Right.
Okay, so next question. It's been a while, but I received training before on the IEP and was informed that at times the IEP meeting can occur without a parent being involved. Is that still the case?
Yeah, so if the school district attempts to make contact with the parent, sends out the notices, and they don't get a response, they can proceed without the parent. But again, the school district has to make that effort. They have to reach out to the parent. Hey, is this a good time to have a meeting? If not, when can you have a meeting? School districts, they're supposed to give parents 14 days. You can't just, spring a meeting, for the next day. So that's what I would say to that.
Okay. And is there an ombudsman to contact and speak to? So I just did a quick Google search on this one because honestly, I've not worked with ombudsmans on education. So with that, through the Department of Ed, it looks like there is a person out there. Looks like her name is Carol. So you can reach out to them. I will try to type that answer to you specifically on that one too. Let's see. Is there a neutral party for the MDR determination? Otherwise, won't the school just say that they did nothing wrong? That is the question every single time, it seems. So, Kyla, do you want to answer this?
So yeah, typically, especially in my experience sitting in on MDRs, yeah, the school will always determine that, they didn't fail to follow the IEP. But even if they decide that, if they determine that the behavior is a manifestation, they have to take extra steps to address it. Whether that be conducting a functional behavior assessment or behavior intervention plan. And so if it happens to where we have to have an MDR again, and we have a behavior intervention plan, was that behavior intervention plan followed? We'll be needing to ask that, and that will be a consideration in whether they failed to implement the IEP. So I usually dig in on that if there's already an existing plan in place. Did the school district take the steps outlined in the behavior plan to address this behavior?
And I would agree with everything Kyla said. A lot of times this is coming down to if it's a manifestation of the disability or not. And I've seen this go either way. So while I agree that the school is often not going to say that they weren't implementing the plan, a lot of times they will say that it is a manifestation of the student's disability. And so I would come prepared as a parent if you don't have an advocate there with you, but to know how your child's disability manifests so that you can know what those key characteristics are. We also recommend bringing professionals to the table with you if your child has a counselor or a therapist or a psychiatrist, somebody that they're seeing. And even, OTs, PTs, somebody who's knowledgeable about the student, speech therapist. If they're dealing with pragmatics, a lot of times that can be appropriate to have that person at the table, someone who can speak to the child's disability and how that manifests for that student. And so a lot of times, we're consulting a DSM-5 to see what those disabilities look like kind of as a blanket according to that. But then the other piece of that I want to add is that you always need to make sure that all of the students' disabilities are included in that conversation, because a lot of times they will only have them listed under one disabling condition in the IEP. And you want to make sure that all the disabilities that the student has a diagnosis of is listed in there so that way all of those are being taken into account, not just something specific whenever there's more going on. So that can be a tough one, but it's one that you can kind of even the playing field if you have some other professionals at the table with you, if possible. And if not, then just know how your students' disabilities manifest going in, because typically you're going to be the most knowledgeable person at the table about your own child. So
yeah.
All right. Does my child have to be out of school, i.e. in school or out of school suspension, for the full 10 days before I can request a functional behavioral assessment?
No, you can request a functional behavior assessment at any time. If you're starting to see, behaviors that, maybe he's not getting, disciplined or sent home, but maybe interfering with, his ability to learn in the classroom, then you can go ahead and request that. You don't have to wait until the 10 days. And that may, the district may need to consider doing that as a proactive measure. So, if we know we have a child that, has certain, maybe sensory needs or environmental needs, go ahead and having that set up so that we can, prevent any incidents happening. So yes, you can request it at any time.
Okay, the next, can you talk more about the extended school year services? I was informed it was for students with severe disabilities. What services are provided through the extended school piece?
So it's not only for students with severe disabilities. Each student with an IEP must be assessed for ESY services. And when we're talking about ESY services, we're going to be focusing on preventing regression. So we want to be sure that kids keep their skills that they learned in school. We want to make sure they keep them over the summer. And so that's what's being addressed. And so that can look like just taking the child to school and having them sit in a classroom and having those services delivered that way. There's flexibility in it, but that's typically how ESY classes look. Jen, do you have any input on that?
No, another place that I've seen ESY be important is students that are needing like counseling. And so something like that is the related service. Sometimes they can continue that on through the summer. We've just had that recently come up to be able to provide those sorts of services. So it doesn't necessarily have to be the full academic piece. It can be different pieces of it that are important for the student too. Okay, do the guidelines for IEPs also apply to any private schools that are receiving Arkansas Learns Act funds? if the private school does not, or if the private school does offer IEPs?
We've seen a lot of school district or private schools offer their own versions of IEPs. I will say, you know, with the Arkansas, the LEARNS, that stipend, you know, families do have to, I believe they have to waive the provisions of the IDA in order to access those funds. So my short answer would be no. But if, you know, the school district has its own similar type of IEP process, you know, we would encourage the parents to be involved in that.
Okay, I'm going to do a piggyback question on that one as well. Are there any requirements for a staff member to be able to form an IEP for a student, such as being a licensed teacher, etc.?
What was the first part of that question?
Just piggybacking on the previous question, are there any requirements for a staff member to be able to form an IEP for a student? So I'm assuming that that is in the private school sector, such as being a licensed teacher, etc.
I'm not sure about that one.
Yeah, if it's dealing specifically with private schools, I think, unfortunately, a lot of the rules go out the window as far as what they're required in the private school sector. But I'm not positive on that either. We deal in public schools typically. So we don't have a lot of knowledge in that area. Sorry.
Yeah, we work with public schools, charter schools, things like that.
Yep. So does anyone at the school refer youth for CES waiver services or provide education there?
CES waiver services.
So it's community and employment support waiver. I don't know.
I'm not sure, but if you will send in your question to that email at the bottom of the screen, we can try to get an answer for you.
I feel like some of that could come in with transition services, perhaps. You know, and looking at the employment piece of that, but I don't have a quick answer for you either. So,
but we're happy to look into that for you.
yes. Okay, why does the reevaluation take 3 years?
Because that's what it says in the IDEA or IEP law. I don't know why they settled on 3. That's just what they chose. 3 is the magic number.
So I would say that's where the requirement is. But if you feel like someone needs to be reevaluated before that, it's something that you can take to the school to address. If it's a situation where you feel like they didn't get the right results in an evaluation, maybe a student wasn't eligible for an IEP based on the results that they got from the first evaluation, that's where that independent educational evaluation can come in. Otherwise, this is just the whole comprehensive evaluation every 3 years, but I would say it could be done before that if the need is there. So, but the hard, fast requirement is 3 years. Okay, do special education services from public schools work over the summer? Meaning I can contact them to discuss IEP over the summer or extended school year, since we're at the end of school year already. That one's tough.
Yeah.
So a lot of times the teachers and the required people are not on contract during the summer. And so it gets really difficult. That's why May gets packed full of meetings. I know Kyla and myself have both been in meetings constantly this month specifically because everybody's trying to get their end of the year meetings in. And usually their year reviews, a lot of those are coming in May, all of that. So if at all possible, I would recommend trying to get that meeting in before the summer.
If you have any concerns that come up over the summer, I would send them to the special education director just until the folks come back on contract, so you can call an IEP meeting.
And then what is the appeal process for a former Little Rock School District student who is currently homeschooled who was rejected from placement at ASBVI? So it's the School for the Blind and Visually Impaired.
I think you would need to contact us so that we can discuss your case in a little more detail.
Okay, I don't see any more questions right now. So is there anybody who needs to raise a hand or anything? Got just a couple minutes if anybody has anything else. Otherwise, thank you guys so much for your time. We've really enjoyed everybody's participation today, and we thank you for attending. And if we can be of any help, then feel free to reach out.
If you have any follow-up questions or anything, please feel free to reach out to us at any of the contact information on the screen. We also have a help form on our website that you can submit. If you do it that way, we can kind of get more into the details of your situation. So if we were really able to discuss your question, we would encourage you to do that. Otherwise, I think we have covered everything.
Yeah, so y'all have done great. Thank you so much for answering those questions and for the great presentation. And thank you for everybody who attended today. And yes, like Kyla said, we do have helpful links and tips on our website. And if you just have any questions at all, you can reach us at info@Disability Rights Arkansas, and we can, go in more depth about, some extra cases. So, okay, thank you guys very much for being here today, and hope you all have a great day.
Thank you guys.
Thank you.
Bye.